Oh,
You don't talk, because I'll remove you from the courtroom. Ma'am, I don't know, maybe you've never watched a show on TV where there's a trial, but when an attorney stands up and says object, the witness doesn't talk, okay? So whether or not they've had 40 conversations or 4,000 conversations doesn't get you there. Not in a limited light of questioning.
we are.
Oh, G. All right, let's have appearances on G.
Thank you, Your Honor. Stephen Kaplan on behalf of the people.
Thank you, Judge Oakley, Zachary Hallman on behalf of Miss G, who's standing to my left.
All right. Thank you. Have a seat. Are we ready?
Yeah, Your Honor, this will be following one word.
All right, let's get going. All the way up front, man. All the way up here. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth today?
Yes.
Watch your step on my incline ramp right here. Settle in that chair. Once you're seated, go ahead and state your name and spell your last name.
My name is Tammy Fixby. My last name is Highsby.
Thank you.
Yeah. Good morning, Miss 60. Where do you live?
I live in
What is your address?
35514 Golden Boulevard, Romans, Michigan.
Do you know a woman named Jakina G?
Yes, that's my neighbor.
If you saw Jakina G again, you think you'd recognize her?
Yes.
Look around the court and tell the judge what you see.
I see that.
Where does she wear?
Green sweater.
Your Honor, may the record reflect the witnesses identified in the speech.
Noted.
Thank you, Your Honor. Without going into a long story, I just want to know how long have you known this?
I don't really know her. I never really talked to her.
Had you seen her before this date,
Yes.
January 8th,
Yes.
2026?
Yes.
Can you tell the judge the number of times you had seen her January 8th, 2026?
Like we just meet outside.
It could be in person, it could be outside, it could be to a car, so many times you've seen her.
I've seen her a lot.
Now, regarding the date of January 8th, 2026, and around me, did anything unusual happen?
Yes.
What happened that was unusual?
I was starting with the patient.
You were threatened by a taser, by who? With a taser by who?
She
Where were you and where was Miss G when she threatened me with the taser?
I was by my front door and she was by her front door.
How far do you live from her?
Like 3 steps away. We share the same wall.
You said you were threatened with the taser by Miss G. What do you mean by that?
She brought a taser outside and was zapping it at me 3 times and was telling me that she also had a gun inside. She couldn't use it out.
But what did she do when she were pointing the taser at you?
Yes, she pointed at me.
Can you estimate for Judge Oakley the number of feet between you and the defendant G when she pointed the taser? With the judge's permission, I'm going to walk towards you.
Go ahead.
I'm not going to debate your space, but stop.
Right there.
Judge, may the record reflect the distance of about 6 feet?
Counsel, you agree? About 6 feet?
Well, Your Honor, excuse me, I'm sorry. Your Honor,
That's right. You don't have to jump up for me.
I'm not sure that I can agree because the distance is an element, we believe, of the case that we're not going to sit.
Okay.
Thank
The actual distance.
I would say it was approximately 6 or 7 feet. Move on.
you, Your Honor. Can you describe the taser?
It was about that long. Like we were just like this. It was, and then it would like kind of went like that. Kind of like the big old ones.
Did you tell me the color of the taser?
But
What were you thinking when she pointed the taser?
that she was gonna use it on.
Did she use that?
No.
How does this end? You said she pointed the taser at you, and then what happened?
I went inside and I had to go out my back door to be able to leave because every time I went out my front door, she would start up again.
What were you thinking and feeling? The taser was pointed at you.
I was scared for my life.
Thank you.
Mr. Holman?
May I approach, Your Honor?
Sure.
Thank you. Ms. Sigsby, how are you this morning?
I'm good, how are you?
I'm doing my best. I'm Ms. G's attorney, and my name's Zach Coleman. I have a few questions for you today as well. If you don't understand the questions I have, which is entirely probable, just re-ask or ask me to re-ask the question, please. Don't try to guess. Mr. Capital will take care of you in that regard too. Isn't it true you lived as Ms. G's neighbor for over 3 years?
Yes,
And in that time, since you've lived with her, is it fair to say that there was a period where you were more amicable with her than you are now?
Objection relevancy doesn't establish an element of the crime or disprove an element of the crime. They can be best friends or mortal enemies.
If Your Honor, if I may continue with the line of questioning, you'll see where I'm going with this.
Without a response to the relevancy objection?
I think it's entirely relevant. It goes to the reason that the complaining witness made the call to the police. It goes to the nature of why the matter escalated in the first place that day, as to what she saw, as to what other complaining witnesses saw. I think to narrow it down to the element of whether Miss G had a taser that day or not is a little too narrow for the scope to that response.
Your Honor, she either pointed the taser at her or she didn't point the taser at her. That's what we're here to discuss. We're not here to determine whether they're best buddies or mortal enemies.
In fact, though, Your Honor, we are, because one of the essential elements to describe is whether Miss Sigsby was truly afraid of her life. So if she doesn't know her at all, as she testified, or whether she does know her, and this is just an issue between the two of them, where she knew that Miss G was actually not going to go retrieve a gun and fire it at her, but it was a continuing issue between the two of them, then that does impact Miss Sigsby's state of mind, whether she was in fear of her.
Go ahead.
Sorry.
No, you're all right. Go ahead.
Felonious assault can be proven one of two ways. It's either an attempted battery or an attempt to place somebody in fear of suffering a battery with a dangerous weapon. So I don't see how this inquiry and announcement being this inquiry proves or disproves anything controversy. Might be interesting. Maybe a jury wants to hear the details, but you don't need to know those details.
Then, Your Honor, it goes also into Miss G's state of mind. And how well they know each other, it is absolutely relevant to what Miss G intended that day.
I don't think her state of mind is relevant at all. It's whether or not the alleged victim was put in fear.
Well, then I stand by my previous response. I do think that the level to which she knows Miss G, if she had just moved in, she's never seen her before, or if she's seen her as her next door neighbor for the last 3 years, is relevant as to whether she was in fear for her life.
I'll allow very limited questioning on that specific issue. What this witness knew about that lady's propensity for threats or violence, because that's what you're saying.
Thank you. So, Ms. Sigsby, let me back up before we got a little sidetracked. I think my last question was, you've lived next door to Ms. G for 3 years, or over 3 years, right?
yes,
And so over that time, how many conversations have you had?
probably
Objection
five,
as to relevancy.
Probably 5.
like 5 or
Okay.
sharing stuff.
Wow.
All right.
The
How
judge
many
is officially
conversations
done
you
playing
said?
around now.
Oh,
You don't
You can
talk,
hear the frustration building with every interruption.
because I'll remove you from the courtroom. The issue is whether or not she thinks this lady has the ability to if a threat is serious. That's what you were relying on, right? Okay, so whether or not they've had 40 conversations or 4,000 conversations doesn't get you there. Not in a limited line of questioning. So maybe you got to ask her specific questions about threats or violence.
Has Miss G ever before the date that we're talking about here made any threats or
Objection. It's not relevant on the day of question. That's what we're concerned with.
I'll allow it. I'll allow it on a limited basis.
Yes, before the day in question.
I wouldn't say threatened,
Okay.
that I know, like, I didn't know her like that. The first time I met her, she called the cops on me. Because she said I parked in her parking spot. I've always tried to stay away from
None of
her.
this is relevant.
Yeah, let's move on.
I did not.
Okay, there's no question.
Okay, Your Honor, I believe Mr. Cavan interrupted when she was answering the question that I posed to her. And,
She was talking about your client calling the cops on her because of a parking violation.
right, and I believe before that, you were interrupted, said that you've had about 5 conversations.
Very limited conversation.
Well, I'm asking you about those limited
And
conversations.
we object as to relevancy.
And in those limited conversations, your testimony is before the day that we're testifying about today, she had never made a threat towards you.
Objection as to relevancy is not an element of the crime.
I'm allowing it.
She has not threatened me, but she has done stuff to try to provoke me. That's what she always has been doing, and I kept forgiving her. I just want peace.
What was she doing to provoke?
Objection.
Never done my door.
Okay, okay, ma'am. I don't know, maybe you've never watched a show on TV where there's a trial. But when an attorney stands up and says object, the witness doesn't talk,
Okay.
okay? Make your objection. Response.
Your Honor, I think if I can request for an instruction, if we're gonna get the same objection, Mr. Kaplan, every single question, it is an essential element of the crime. I am keeping my questions very limited to what you narrow the scope of this line of questioning to, and we're still getting an objection every time. It seems like we're clearly trying to interfere with the complaining witness's testimony. I'm asking very specifically about her frame of mind on that day. That is contextualized by the history she has with my client.
I'll allow it.
What would my client be provoked?
Smear hamburger on my front door after I went to work.
When did that?
Your Honor, we object. These are prior bad acts under 404B, and they're being introduced against her, this client.
If he wants to introduce him, let him. I get to decide that today.
And she has followed me. I had to make a police report after what happened, because she was following me and my daughter twice.
And when in proximity to the day in question that we're testifying about today, did the 2 incidences that you just described, to the best of your memories?
When did they happen?
Yeah.
About a week ago, 2 weeks ago.
Okay, so did this, my initial question was, times you interacted with Ms. G, my client, before the day in question. Okay.
We object. It's been asked and answered, and it's also not relevant.
And it's confusing. So this incident happened in January, yes, ma'am?
Yes,
The taser incident.
yes,
The incident with the hamburger and the following, was that before January or after January?
before.
Okay, about 2 or 3 weeks before?
No, about a year.
Move on.
Okay, so any other incidents of provocation that the term of use from my client besides the hamburger, I don't even know the incident of stalking where you call police?
Since after,
Before January.
Well, I'm sorry, before June.
there was incidents where she would be like trying to provoke me, or she would try to get information out of me, apparently, because of the stuff that she was saying on the day of the incident, of information that she knew, and the only way that she would know that information is if she was following.
Okay. Yeah. My initial question, yes, I agree with Mr. Dickens, it's no longer relevant. But just to close this line of question, was there any other incident with that, let me re-ask, besides what you've already testified about, before the incident in January, did you have any other interactions with my client where she either provoked you or allegedly threatened? Okay. Were you looking for a reason to call the police on Ms. G?
No,
Why did, on the day in question, in January, isn't it true that your mother-in-law was involved in these?
Objection,
Or
that's the problem.
I don't have a mother-in-law.
the,
Objection, as a competency.
Okay.
Doesn't prove or disprove anything in controversy.
well, actually, Your Honor, the response is, I move you to the day in question, and there is another witness, and I'm sorry, it's a familial relation, and I'll correct the record, but absolutely, she was involved. She bore witness to Miss G being there, and my line of questioning is about where ultimately the complaining witness was when the alleged threats were.
We have a trial within a trial here.
Yeah. And she's already testified that they were approximately 6 or 7 feet away when the taser was involved. So I don't know what more you're going to get about proximity.
Well, then let me narrow it down, please, Your Honor.
Try.
Thank you, Your Honor. My line of questioning is specifically, where were you in terms of your proximity to your doorway of your apartment when Miss G allegedly threatened with her taser, alleged taser?
I was on my front porch next to my front door by the farthest, right here. So I just walked out.
You had just walked out of your porch.
I just walked out of my house.
Onto your front porch.
Yes, onto my front porch.
Thank you.
Wow.
So you had just walked out of your house onto your porch,
Judge, been yes and answer.
It is. Go ahead.
and was that the first time you saw Miss G with what you believe was a taser?
Yes, because she's acted at me.
Hold on, if you could just answer the questions that I asked you, please. When did she at it?
She walked outside. She walked outside screaming, talking about she had a gun in the house. She was going to shoot me with it, and she had the taser in her hands, and she's acted 3 times that day.
Okay, that was when you came out of your house.
Yes.
So
Your Honor, excuse me.
where was it?
I'm being distracted by the.
I'm going to put you in the lockup. If you can't sit there without making any noise, you'll be removed from the courtroom. Do you understand that?
Okay, so my question really was, when did Miss G threaten you with the taser? Was it before you went into your house? After you came back out of your house? Both?
She said she stepped out of the front door onto the porch. Your client came out and they had the confrontation on the porch.
If I may.
No, you can't. I got 6 exams today and I don't need to hear the same stuff 4 times. Ask a new question that elicits new information.
Okay, where was Miss G when she threatened you with the taser?
On her front porch.
Where in proximity to your house is her front porch?
Like
6 or 7 feet away. Sit down. You're done with cross. Do you have any redirect? Thank you.
Put my objection on the record.
Feel free. Any other witnesses? Any defense witnesses? Any argument?
Yes, Your Honor, the witness testified a taser was pointed at her distance of 6 to 7 feet. She was afraid, actually fearful for her life. Thank you.
Your Honor, we don't believe the elements of felony assault with a felonious weapon that occurred here. We believe, if anything, the charges should be dropped to misdemeanor assault. And we asked that he would find that the prosecutor did not meet his threshold for a preliminary exam and would not find him so. Thank you.
Because there was no testimony about a felonious weapon?
Your Honor.
I'm not familiar with what a felonious weapon is.
Your Honor, I would have gotten into more details regarding what what our lovely complaining witness perceived the weapon to be. I will reserve that argument for circuit court. I don't believe that it's a felonious weapon in this case.
Okay, I don't even know what a felonious weapon is. Is that the same thing as a dangerous weapon?
I don't believe that it meets the definition of a dangerous weapon, making this a felonious charge.
Okay. Bound over. AOI is next week, 9 a.m.
Thank you, Your Honor.
Say again? What? Oh, yeah, you can step down, ma'am.
And just like that, the case moves forward. Weeks of arguments, interruptions, objections, and accusations all led to this one decision from the bench. The judge stayed patient, stayed in control, and made it crystal clear that courtroom chaos was not going to distract from the facts.